Welcome to Rebel Chaser. My name is Gail, and I've got several videos for you tonight. I've got two from Judge Mertz, one from Judge West, one from Judge Chisholm, one from Judge Hesselink, and one from Judge Crum. So I'll let you watch.
All right, good morning, everyone. We'll go on the record now in Lee versus Lee. This is file number 2419864. If I could have counsel for both sides put your appearances on.
Yes, good morning, Your Honor. This is Matt Motley appearing on behalf of the plaintiff.
Good morning, Judge Elliott Blumberg on behalf of the defendant, who's actually in my waiting room. Can I just wait a moment to bring him in?
Sure, absolutely.
Thank you, Judge. He's now in my office.
Okay. All right, the record should reflect Ms. Lee is also connected by Zoom video. This is set as a status conference in this file today. Mr. Motley, on behalf of plaintiff, can you tell me where things are at? I think this is your first appearance on the record anyway for Ms. Lee. So can you tell me from your standpoint where things are at and what we need to do for scheduling going forward?
Change the scheduling. I mean, I'll just start by saying I think 90 days of discovery would be sufficient. I know we still have that pending hearing with the friend of the court coming in September for the issues relating to custody, parenting time, and child support. So if nothing gets settled before then, I anticipate that hearing would resolve those matters. But either way, I think 90 days of discovery would be sufficient, giving us maybe 120 days to mediate. I'm confident that we can select one in advance of that. So I think that as be a starter here is just getting these next steps done.
Thank you, Mr. Blumberg.
Judge, while I don't disagree with counsel's request in terms of discovery and scheduling, there is an ongoing violation of your court order. Ms. Lee continues, in spite of your order, to deny my client parenting time. We continue to file complaints with the friend of the court, but hearings aren't scheduled out until September or later. I think you'll remember that Ms. Lee was represented by prior counsel. We had most of the day to come to an agreement. There was a signed agreement prepared. Ms. Lee fired her attorney and then refused to sign the order. You subsequently signed that order, but she continues to ignore it, and my client does not have the opportunity to see his kids. So if you want to know the status of the case, that's a major problem right now.
Okay. Mr. Motley, have you discussed that issue with your client?
We have, and I mean, we more or less filed an objection. I mean, again, without getting into the substance of what this is, what the agreement or the alleged agreement happened. Obviously, I think we have a different position on this. I'm understanding that there's a hearing set in mid-September to address these issues. Otherwise, I think the parenting time's been going on schedule, but I think the major point was the no contact order due to the pending criminal conduct case against the defendant here, that he's not supposed to be at these pickups, which I thought was a major term of the agreement. That, again, I talked to her attorney. I don't know all the substance of the agreement, but I know if the parenting time schedule that was in place is supposed to be in place, that he was not to be doing these pickups and drop-offs just by virtue of the no contact order that's there. And it's my understanding that he's been going to these. That is one piece of it, but again, I don't want to get into the substance of that today.
All right. Well, I mean, that's an issue that's going to have to play itself out, you know, according to the normal procedures of the court. I guess I would just say, you know, there is an order in place, Mr. Motley, to the extent your client is not following that. And you guys, you know, everybody's going to have a chance to argue about whether that order should stay in place or not based on what happened previously. But the fact is, there is a court order in place, and to the extent that your client is just willfully violating that because she doesn't agree with the way that order got entered, that's not a reason to just not comply with the order. So all I would say is, to the extent that she's found to be failing to comply with that order and not having any legally justifiable reason for doing so, I just think you need to caution your client that the court, I would fully intend to use the full weight of the court's contempt sanctions to compel her to follow that order if it's not changed, and she needs to be following it now. And to the extent, Mr. Blumberg, that your client is doing something that's in violation of that order, that only hurts your client in terms of his ability to have that enforced. So I think both sides need to follow the order to the extent that either the referee or the court or both find that neither side has appropriately followed it or either haven't. I am not going to tolerate from either of these individuals, Mr. Lee or Miss Lee, just ignoring the court's order. In particular, in this case, I think the court needs to take a hard line with both of these individuals because I think they both just want to do what they want to do, and that's just not going to happen. The court's orders mean something, and to the extent that either side isn't following them, both Mr. Lee and Miss Lee need to be prepared to pay the price for that once that's determined. So that's all I'll say with regard to that. This is a status conference. This isn't an evidentiary hearing. I'm not going to make any findings on that, but I just want both counsel to caution your clients that I'm just not going to tolerate it in this case. And again, in particular, based on the evidence that I've heard so far as to the actions of both parties. So that being said, I do think, and there was no objection to it, I do think Mr. Motley's suggestion in terms of scheduling is appropriate. So the court will enter that in terms of a scheduling order. 90 days for discovery, mediation to occur within 120. The court will set this for another status conference at that point. Otherwise, the parties will proceed in front of the court, and to the extent there are objections to the front of the court rulings, we'll get those scheduled in due course as well. Mr. Motley, is there anything else that I can address for your side today?
I mean, there are minor stuff like the witness list and exhibit list, but I assume the court's just going to outline that in the scheduling order that's going to result from today's hearing.
Well, yeah, I mean, if we need to, this is going to get us going up through mediation. If there aren't any agreements, then we'll set additional dates for court hearings, and we'll schedule those types of matters in with that.
Yeah, that's all I had, Your Honor.
Okay, Mr. Blumberg, anything further from your side today?
No, Judge, thank you. I appreciate you addressing my concerns. Thank you.
All right, thank you. That's all for today. All parties on this file are free to disconnect. And Mr. Blumberg, I'm just going to put you on hold for a minute. I know you have the other 9 o'clock hearing as well.
I do. Thank you.
Thank you.
Everybody connected, so we'll go on the record in Cruz versus Cruz, file number 2319351. If I could have counsel put your appearances on, please.
Good afternoon, Judge Elliott Blumberg on behalf of the plaintiff, Danny Cruz.
Good afternoon, Your Honor. Chris Kolumchek on behalf of the defendant, and I do have laryngitis today. I'm sorry.
Okay. All right. This is set. I know we've been dealing with this case, Mr. Blumberg. I believe, if I recall correctly, you were having difficulties contacting your client. We're trying to get the judgment entered here. Mr. Blumberg, can you give me any updates on where things are at from your side?
Yes, Judge. I received a proposed judgment from opposing counsel or his legal assistant some time ago. I had responded in an email. There's just a number of provisions within this judgment that were never discussed and certainly never agreed to. So the judgment also references a uniform spousal support order, which has never been provided to me. So the judgment that I have does not comply with the terms of the mediation agreement, and it doesn't, it contains provisions that the parties never agreed to.
Judge, with regards to that, first of all, we're the defendant. We've been waiting for months now for the plaintiff to produce a proposed judgment. So we started the ball rolling by doing what we did. With regards to the uniform support order, he's supposed to produce that since he's the plaintiff and include it with the judgment. But that's going to be a uniform order. There's no reason not to sign the judgment. We all know what the uniform support order looks like. So we did this back in June 16th. We gave a proposed judgment after waiting week after week after week for one from them. And I have no idea what's going on or why this is taking so long. They never responded since June 16th, other than to say he would check with his client.
That's not correct. But Judge, if you want, we can go through this judgment and we can talk about all of the provisions that were never discussed, and certainly the ones that never were agreed to, including a mandatory arbitration provision. I don't know where they came up with that. It's never been discussed. And it's inconsistent with the provision that talks about this court having continued jurisdiction. I mean, there's just places in here that they just put in whatever they wanted. And I'm certainly prepared to either have a hearing on that, an evidentiary hearing, or we can go through it provision by provision, because it's just totally inappropriate.
Well, why are you waiting till now to say it for the first time? And with regards to the arbitrary, the arbitration, mandatory arbitration, that's for personal effects. Now, we do that all the time when they go to mediation so that they're not fighting over, hairbrushes in court. Now, all you have to do is strike it, and we would have said fine. But that's something that we put in our divorce judgments routinely. But to say it's somehow not purporting to what we've all agreed to is ridiculous.
You go to mediation, not binding arbitration.
No, that's just for personal. All right, strike it. We have no objection. If you're willing to sign it right now, strike that. Is there anything else you'd like to strike?
Yeah, there is.
Here, I'm gonna put, hold on a second. This is what I'm gonna do. I'm gonna put counsel into a breakout room. I'm gonna let the two of you hash this out. There's no reason why I need to listen to it or for it to be on the record. And then let's bring you back in, and if there are provisions that we can agree to, or if you guys can hammer this out now, I mean, I think everybody acknowledges that we need to get this done, and I don't know. I haven't seen any, what the proposals are. So I'm going to put counsel into a breakout room. I'm going to let the two of you see if you can hash this out. And if you can't, then we'll have to figure out where we go from there.
Judge, so you know, we did submit a copy of the proposed judgment in our motion to enter judgment. Because we have a motion pending today, motion to enter judgment at the same time as the status conference. And we have a proposal there. Yeah, okay.
No, I looked at that, but from my standpoint, I don't know what the agreements are between the parties, so I don't have anything to compare your judgment to know whether or not it comports with the agreement or not. I'm
sure we can hammer it out right now. It shouldn't take very long.
All right, so I'm going to put counsel into a breakout room along with the clients, and let's see where we go from there. So just 1 second. Okay, Mr. Blumberg, we're good. Okay, hold on 1 second. Okay, we're back on the record in the Cruz matter. Mr. Blumberg or Mr. Podrick, were we able to reach any agreements?
Yeah, Judge, I think we are. I don't know I guess what's being requested of you is you have a copy of the proposed judgment in front of you?
I do.
Okay, so some of these provisions are going to be crossed out in total, and there's going to be some revisions made to others. So do you want to go through page by page?
Can we make a record of it, and then since you're plaintiff's counsel, or, well, I don't know, however you want it, whoever, Mr. Klomjic already went through the time of drafting the judgment, whoever would be easier, but what I'd like to do, I guess, is make a record of it, have everybody agree to it here, to the language, and then have one of the counsel submit a clean copy for the court to sign.
Okay, well, Judge, if you would turn to page 2 of the proposed judgment.
Okay.
We're under the provision of uniform spousal support order. It references the attached uniform spousal support order. We both acknowledge that hasn't been prepared, and I will be preparing that for the court.
Okay. Mr. Klomjic, is that correct?
Yes, Your Honor.
Okay,
The next real changes appear on page 5.
okay.
The provision under escrow accounts going to be omitted.
Is that correct, Mr. Klondike?
Yes, actually, the whole page is stricken.
That's right. The entirety
Okay.
of the arbitration clause is removed as well.
Okay,
Page 6 is fine in its current form. Page 7, we didn't really discuss in detail, and I need to talk to counsel about language that he put in there that, again, were never really discussed. And candidly, some of it may be accurate and some may not, but that page of the judgment is, from our perspective, not ready to be entered by the court.
okay,
On page 8, there's going to be a revision to the provision that the paragraph that says, for purposes of qualifying the defendant, the member and former spouse acknowledged that they have been married for a period of more than 10 years, during which time the member performed more than, that should read, 7 years of credible military service.
Mr. Klondike, is that correct?
Yes, Your Honor.
Okay,
And frankly, Judge, the remainder of the judgment's fine in its current form.
all right, Mr. Klondike, is that correct?
Yes, Your Honor.
Okay, so here's how we'll proceed. I would like to have a clean copy prepared with regard to the language on page 7 regarding the military pension. Within 30 days, if counsel are not able to agree on the language under military pension, then I'm going to ask each counsel to submit in writing their proposed language for that. We're not going to schedule any further hearings. The court will, if there isn't an agreement and each counsel submits their proposed language for that, the court will adopt the language it finds most closely comports with the mediation agreement. I did look through the file. I do have a copy of the mediation agreement in the file. So I'll be able to make that determination. And then the court will enter a final judgment in this case within the next 30 days. Again, if there's an agreement, the court will enter it based on what the parties, the clean copy that's submitted. If there's not, then the court will, again, make its determination. The only thing now, since we've been on the record, everybody's reviewed it. We've got the agreements on the record that have been made with regard to the language here today. So in my view, the only thing that the court would consider any kind of further debate on is that language under military pension on page 7. And again, the parties, if they can't agree, will need to submit written proposals for that language. The court will make that decision without further hearing based solely on the mediation agreement and the submitted language. And then again, the court will enter that judgment within the next 30 days. Mr. Blumberg, do you have any questions or issues with that process?
Not that, Your Honor, but does the court records reflect that we took the proofs in this case? Because we're prepared to do that.
We did take the proofs.
Okay, thank you.
So really, it's just a matter of entering the language, the judgment. So, Mr. Klondike, do you have any objection to that process to get this finalized?
No, Your Honor, none.
Okay. All right, thank you. That's all for today then. All parties are free to disconnect at this time.
Thank you, Judge.
Thank you.
Mr. Macon, you have Gracie Cassidy. It's a sentencing.
We're ready, Your Honor.
Good morning. You're Gracie Cassidy?
Yes, ma'am.
And Ms. Cassidy was previously in court and entered a plea of guilty in cause number 24 DCCR 1480 to the third-degree felony offense of unlawful carrying a prohibited place. I've received the pre-sentence report. Has everyone had an opportunity to review that report?
It has.
Yes, Your Honor.
Are there any additions or corrections?
Your Honor, the only, fact I would like to say is she's now living in Georgia and it'll be transferred to Georgia for supervision.
Just make sure when you talk to probation, they'll get that all taken care of. The biggest thing about your probation being transferred is it kind of means you have double duty. So you will be reporting in person where you live, but you're still technically on this probation here in Texas. So it's not like the whole. Well, no, there's one fee, but you will have to report either by mail or online here as well each month. So you're going to go in person there, and you also have to report here. So you can't forget to do that mail-in or the online reporting here, because that would be a violation. It's just a lot of people they think they're doing everything right because they're reporting in person over there, but you have to stay in touch with us as well. All right.
Judge, real quick, I apologize. There is one thing, and I spoke to Mr. Megan about this previously. There's,
That's right.
it seems to be maybe a new charge in Georgia. I don't know I don't know the circumstances of this, nor do I recognize the charge.
Yeah.
And it's equivalent with us.
Hang on, ma'am.
So that's the only thing that's new that I wasn't aware of, and I spoke to Mr. Megan about before, and he was gonna find out.
Okay, so whatever you have to take care of, obviously in Georgia with regard
I
to.
don't have anything to take care of. That was like what they were holding me on in Georgia.
That's the case, Judge, but
But I got in a car
I
accident and they arrested me because I had a warrant here.
I got you. Okay. All right.
But I already dealt with that. Well,
Okay.
there was nothing to deal with. I just had to find out.
That's where you got arrested and then they transferred you here?
I didn't get transferred. I just had to sit in jail for 44 days
Okay.
to find out.
Okay. Got it.
that's
Okay.
sufficient for the state.
All right.
I just didn't know.
Okay, Ms. Cassidy, I'm going to find that you previously entered your plea of guilty freely and voluntarily. Find sufficient
I have a question.
Yes.
This packet, it said like I had to do like 300 hours of community service.
She'll explain all that to you at probation.
Yeah, that's what happens when you're on felony probation. It's required. If you talk to your probation officer, if you're doing everything right, sometimes they waive part of those. Sometimes they don't. It depends on how you're doing. Do you understand? This could be a lot worse, so you probably need to fix your attitude real quick. Because having a bad attitude with me does nothing good for you. Okay. So I'm going to find sufficient evidence to find you guilty, and at this time, I'm going to follow your agreement and defer all proceedings and place you on probation for 4 years. You're ordered to pay a $500 fine and to follow all of the rules and conditions of probation. If you do that, this is an excellent opportunity because you do not have a felony conviction on your record. And if you successfully complete the probation, at the end, the case is actually dismissed. You will never have a felony conviction. The other side of that, though, is if you violate any condition of probation, you can be brought back into court, you could be found guilty and sent to prison for anywhere between 2 and 10 years. Do you understand? Okay. One thing is, on these types of probation, if you do everything you're supposed to, I sign early terminations from probation all the time. But it means you have to get it all taken care of early and up front. So take care of everything, and then there's the possibility of getting off early. I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. You need to have a seat here in the courtroom. Probation's going to call you up to her desk when she's ready to go over your paperwork. All right, good luck to you, ma'am.
This is 25 R Rose 04301. Ms. Gonzalez, the ticket was issued on the 1st of July, about 3:08 in the afternoon. Near Rochester Road and Dewey Streets in Royal Oak, and you were cited failure to yield, and there was a crash. You can admit or deny responsibility, or you can admit responsibility with an explanation. How do you wish to proceed?
I want to contest this ticket. I do not feel that I was at fault.
Okay.
And I want
Raise your
to
right hands,
explain
please. Do you swear or affirm that the testimony you're about to give in this matter will be the truth?
I do,
Yes.
Your Honor.
I do.
The officer will testify first, please.
Yes, Your Honor. On Tuesday, July 1st, 2025, at approximately 14:48 hours, which is 2:48 p.m., I, along with Officer Carr, responded to an injury accident in the intersection of Rochester Street and Dewey. Unit 1, who is a defendant here, was southbound Rochester making a left turn to go eastbound on Dewey when the defendant driver struck the front center of the other vehicle's vehicle. The other vehicle stated that she was stopped at the stop sign on on Dewey Street on westbound, going westbound, waiting for traffic to clear to turn left onto southbound Rochester. And that was when she was struck by the defendant, who was making the left turn from southbound Rochester to eastbound Dewey. Your Honor, when the accident occurred, the other driver that was stopped at the stop sign advised that she exited her vehicle and forgot to place the vehicle in park. And this caused her vehicle to reverse and hit two parked vehicles that were parked on Dewey Street that were facing eastbound on the street. Your Honor, the fire department responded to the scene and transported the other driver of the vehicle to the hospital for a left wrist injury. And then one of the vehicles from the scene was towed away. Based on witnesses' interviews and the defendant's story on scene and the other vehicle's other driver's story, it was determined that the defendant was at fault due to her making the left hand and her having to yield to oncoming traffic, to traffic before making that turn. And that is when I issued the citation for failure to yield, causing an accident.
Was the other vehicle involved in the crash northbound on Rochester or westbound on Dewey?
Westbound on Dewey, Your Honor.
Were you able to locate the debris after the crash?
Not that I can recall, Your Honor. There was some debris from the parked vehicles that were hit, as well as her vehicle from where her vehicle was originally at, and then where the vehicle was reversing back to and hitting those two parked vehicles.
So the other driver was not in her vehicle when it backed up and hit the other two parked cars?
Correct. She was already out on the curb, waiting for the fire department to come check her out.
Thank you. Ms. Gonzalez, it's your turn now.
Yes, correct. I was traveling south on Rochester Road. There are no yield signs, no stop signs, no lights. So I had the right of way when I made the left-hand turn. There was no oncoming traffic. My attention was focused on making sure that there was no oncoming traffic before turning east onto Dewey. The other driver was stopped at the corner. Now she had the stop sign. She's the only one who had the stop sign. Now the stop sign is like approximately 12 feet from the corner. And I believe that she moved her car forward in order to make her left turn. I have pictures of her vehicle. There was no debris. The crash site or the crash is to this side of her car, the passenger side. So if she were behind the parking sign, there's no way that I could have hit the passenger side of her car unless she had moved her car forward already, already trying to make her turn. There is no way, and it happened so fast. When I was making my turn, all of a sudden she appeared there. It was like, where did she come from? And when we struck, all of a sudden she exited her vehicle. And then, as he mentioned, the car rolled back. So, and I was trying to get her attention to let her know, hey, your car's rolling back. But everything was happening so fast. And she immediately walked to the sidewalk and was on her phone. And then her car went backwards. That's another part of the story. But I truly believe that I was not at fault. My ticket was given for failure to yield. How could I have had failure to yield when I didn't have a yield sign? I didn't have a stop sign. She was the one with the stop sign. And because of where her car was struck, if she was behind the stop sign, here's the picture of the stop sign. how could I have struck her passenger side unless the nose of her car was already sticking out? And there was no way for the officers to determine the position of the vehicles because they weren't there. Hers was down the street, and I moved mine to the curb. So when they were there, they couldn't see the positions of the car to see who was at fault. I could, it just happened so fast, especially when her car started rolling back, then it was like another issue. So I want to contest this. I do truly believe in my heart that I was not at fault.
What part of your vehicle was in contact with the other vehicle?
Pardon me?
What part of your vehicle was in contact with the other vehicle?
I have a picture of that. My driver's side.
You're
Right.
showing me the front and saying the side.
Right over here is my side, and then hers.
Ma'am,
hers is
please stop.
Okay.
I asked you what part of your vehicle was in contact with the other vehicle, and you said the driver's side.
The driver.
And then you showed me the front of the vehicle.
My driver's side towards.
How does the side of your car, do you mean the front of your car towards the driver's side, or are you actually meaning it was the driver's side of your car that was in contact?
Okay, going for the front, I don't know, okay. The driver, my side, the driver's side, towards, a little bit towards, not in the middle, not at the very end, but like right, well, I tried to show you a picture.
Are you talking about the front of the car or the side of the car?
The front of the car.
Okay.
The front, I'm sorry, the front of my vehicle, my car.
And what part of the other car was in contact with your car?
The front, her front passenger corner, the corner passenger front of her front passenger side. So if she was coming out and I was turning, then my car hit her passenger side. And if she were behind the sign, there's no way that I could have hit her on that side. Unless she was sticking the nose of her car out towards the street when I was making the turn.
Can I see the photograph of her car?
I have two. It's can you see it? Right around here is where I see the damage. So if she were behind the sign, how could I have struck her on that side? Unless she heard.
I'm not here, ma'am, to answer your questions.
Right. Okay. Well,
Do you have a second photograph of the other car?
The full front. If you're able to see that.
It would help if you keep it stationary a little.
It's right here is the damage. So it's the front. So the cars were not in position of where the impact took place because her car rolled down the street.
Right. I understand that.
Okay.
I have a question for Officer Keikos. When you observed the damage to the vehicles, officer, was the damage to the other car, not Ms. Gonzalez's car, but the other car, was the damage to that car as it relates to the first crash on the front passenger side?
It was based on my report, Your Honor, it was on the front center.
But
of the car, and then as well as when the vehicle backed up, it had the rear center from hitting those parked vehicles.
Well, yeah. And I
What
asked.
side of the street were the cars on that got hit?
It was on. Well, when she was facing westbound, her car was facing westbound, and then she hit the cars facing eastbound on the street. So it was on the east side of the street on the Rochester side.
I'm sorry, did you say where was her car? Her car rolled backwards going east as she hit the cars that were parked on the south side of the street.
That's
So
exactly
her car
what the
went
officer
back and
said.
hit the south side. Yeah.
Okay, a vehicle making a
So
left
if she
turn
were on
has
the
to wait
left
until
hand,
all the traffic. Ma'am, I'm talking. A vehicle making a left turn has to wait until traffic is clear. Left turn always has to wait until traffic is clear. A driver at a stop sign has to wait until traffic is clear before they proceed past the stop sign. It appears that the other driver may have been intending to make a left turn as well, because the damage to the car was in the front and appeared to be front right, center to the right, not center to the left. In those photographs anyway. And if she was, the first thing that you said, Ms. Gonzalez, is that the other driver had stopped or was stopped. I forget which you said, but you definitely said that they were stopped.
well, actually what I said was when I was making my turn that all of a sudden she was there. Now, whether she was stopped or in the
No,
process.
ma'am, you said stop. You said stop. Then you went on to say that you don't know where she came from.
Okay. Well, I apologize, but it's like it happened so fast. All of a sudden she was there. Now, whether she was making her turn or an actual stop, I cannot confirm. It happened so fast. I just know that she was, all of a sudden she was there as I was making my turn. But she was not behind. She was not behind the stop sign. She was already like coming towards the street.
Well,
because if I
the
may.
stop signs are placed on the near side of the sidewalks, so that cars stop before pedestrians walk across. And then most drivers will stop and then they have to pull up to see if it's safe to go. So there's no testimony here that there was a violation that amounted to the other driver not stopping at the stop sign. Whether she stayed stopped long enough remains to be seen. However, you're cited for failing to yield. And when making a left, you always have to yield to oncoming traffic. The other vehicle wasn't oncoming traffic.
Correct. My responsibility was to oncoming traffic.
Well, you're not supposed to hit things no matter, let's say the car is not supposed to be there. That doesn't mean that you can hit them.
Correct.
But southbound, making a left onto Dewey. Another car was coming out. In front of their car gets hit. If you were making a sweeping left turn, not saying you were, if you were making a sweeping left turn as opposed to a right angle left turn, then it would not be impossible that a vehicle making a sweeping left would be angling in towards the center right of the vehicle that was oncoming in the westbound lane.
or it would have been on the driver's side, which it wasn't.
No, it depends what, it would
Right.
depend on when the driver started the sweeping turn. Sweeping
But it
turn
was,
could have just missed the curb on the north side of the street. That's, I'm not saying that's
Right,
what
but
it
the
did, but
damage-
that would be a way to have the damage line up that way.
right, I understand. But I don't see any damage to the center of her car. I see it towards, well, I already showed you the pictures.
Yeah.
And I did ask the officers if they took pictures, and they said they do not take pictures. That's why I took these pictures. I wasn't aware that I was going to be issued the ticket because I was not standing near her, near the other person while she was, stating her side of the story.
Oh,
And
no matter which driver is speaking with the officer, we all perceive from our own perspective. And much of perception is perspective.
Mm-hmm.
And that doesn't mean that the people are misleading the officer. It's they're seeing things from their own perspective. I would imagine that the other driver was, as it would not be surprising that you were too. That's not an indication of an attempt to deceive. It's just we see things from the way we see. And the burden of proof
but I
in a
don't
civil
understand.
infraction informal hearing is by a preponderance of the evidence. That means one side has to hit more than 50% and the other side has to be less than 50%. As I'm looking at these facts, I can say I don't think either side is preponderated. And on that basis, I'm going to dismiss the ticket.
Thank you very much. I appreciate it. Now, how do I go about getting confirmation or verification of this to submit to my insurance company?
The court doesn't mail out these things, but actually what happened here is hearsay relative to the crash.
Okay.
Because this matter dealt with a civil infraction. It did not deal with who's responsible for the crash.
Okay.
Sometimes that might be a difference without a distinction. Sometimes it is significant. But the bottom line here is that the officer submitted a UD-10, which is a form that goes to the Secretary of State after the crash.
Mm-hmm.
After any crash, and the UD-10 is the basis for the insurance company, not what happens in court.
Okay. Okay.
Thank you. Have a good day.
Thank you very much. I appreciate it.
All right, the next matter is Elizabeth Hostman and/or Thomas Serino versus Joseph and Kristen Walsh. That is file number 25-40663-LT, set for a hearing today. I do see the Walshes and I do see Mr. Serino is with us. This appears to be a motion for installment payments made by the Walshes. So who would like, from the Walshes, who would like to tell me what it is that you're requesting and why?
I requested $150 a month to pay back what we owe.
And why do you believe that that would be appropriate?
I bring home $1,300 every 2 weeks. Once you get rent out of that, and groceries, and electric, gas. Gas for the vehicle. I've got an outgoing payment to the IRS every month, $61.
I read the numbers that you used in your motion, which said that your average income is $31.04 each
Okay, I'm
month.
sorry, I apologize. That's with Joe's Social Security.
All right, and then I added up all of the monthly payments that you said that you had, which would include the rent, utilities, child support, phone, cable, and internet bill, Capital One, Sparrow Hospital, auto and renters insurance, prescriptions, IRS, and waste management, and it came to a little over $2,200. So there's almost $900 still left over from that. Why should your payment be limited to $150 then?
Still got groceries out of that, so gas for the vehicle.
What happened to the $10,000 that you should have saved when you weren't paying rent for the number of months that you weren't paying rent for?
I was the only income during that time. That's why we got behind. He was off of work for a year before Social Security would give him his disability.
You're asking for almost 5.5 years to pay off your rent debt. $10,000 at $150 a month is going to take you 66.6 months to pay off.
What do you think?
I don't find that to be reasonable.
What do you think is fair?
I'm not going to negotiate against you. This is your motion. I just told you $150 a month is not. Mr. Serino, do you have an answer?
Well, I did talk with my client, Your Honor, and can you hear me okay?
Yes.
Okay. I did talk with my client to make sure she was in agreement, and she would like $400 a month. We're both, my client and myself, well, I'm 78 and she's older than me, but we don't have a lot of time left, Your Honor, and to put it at 150 is not, one, appropriate, and two, it's discouraging, it's disappointing. Yeah, she wants $400 a month. It's a very large bill, Your Honor. As Your Honor stated, it's going to take 66 months to pay it off at their rate, and we don't. Neither one of us want to be waiting that long for payments.
Ms. Walsh?
I don't even know what. To get the place we're looking for, we're looking at paying almost $1,000 in rent.
And it's in Elmira.
In Elmira. Or $250.
Can I ask why you guys haven't contacted each other and talked about this to begin with? Why are we wasting the court's time negotiating?
I have no idea.
I don't either. That's why I asked the question. I mean, if you want something, you should be on the phone talking to Mr. Serino just about every day, saying this is what I can pay. This is why I can't pay $400. You got $500 down listed as rent in your request telling me what your bills are. You say you can get an apartment or get a place for $1,000. You still got $900 left over. That leaves you $500 or $400 to do whatever you need to do. Maybe you need to get a second job. I don't know. I'm not the one who made the decisions about not paying rent for however much time it was to rack up a $10,000 bill. But you had the opportunity. He gave you the time then. I don't know that he should have to give you more time now. I find that you've got the ability to make another $400 payment. You can either agree to $400 or you can allow Mr. Serino to garnish your wages at whatever he can get it for. Which do you want?
I'm taking over the talking. You got her crying. Thanks a lot. $400 is fine. You get your money. You support the slumlord. Thanks a lot, sir. $400 is just fine.
Then that's
I'm
what it'll
taking
be.
over
Thank
the
you very much,
conversation.
sir.
She
We're
is
done.
crying.
Shut him,
She
please.
is crying.
We're done.
Find out.
Hopefully. How do you find out? How do you find out? Right here?
Yep.
Okay. Oh.
All right, are you Marshall James Wilkins?
Yes, I am.
All right, we'll go on the record in State of Kansas versus Marshall James Wilkins.
Yes,
Case
sir.
number 25 CR 231. The state appears by Darren Deviney. Mr. Wilkins appears in custody from the Butler County Jail. Now, you're here for a first appearance, Mr. Wilkins. There is one charge. It alleges that on August 29th, 2023 in Butler County, Kansas, you unlawfully obtained control over a check in the amount of $3,788.13 with the intent to permanently deprive.
I can't hear, bro.
Hey, are you able to hear me, sir?
I can't hear.
Do you need a, like you can't hear because you need a hearing aid? Or the volume's not loud enough for you?
Or the volume don't fit or something. I don't understand what the deal is.
All right, well, you've been charged with stealing a check from Bestmark Express, Inc. That's theft, a level 9 non-person felony. The value being $1,500, but less than $25,000. Do you understand your charge, Mr. Wilkins?
No,
Okay, what don't you understand about it?
I don't understand the two different charges.
There's just one charge.
Which one is it?
Theft.
Theft?
That's correct.
So what did I steal?
A check.
A check.
Correct.
So
the
that's
intent
in the
to
check?
deprive
Was the check already
Bestmark-
written? Was the check already written?
I couldn't tell you that, Mr. Wilkins.
Then maybe I didn't steal it.
All right. Can you afford to hire an attorney?
I cannot.
Do you wish to apply for court-appointed counsel?
Yes, please.
All right. Are you currently employed?
What?
You have a job.
Do you work?
Man, I can't even hear out my ear.
All right. I'm going to
When do I
appoint.
get to hear out my other ear?
Hey, Mr. Wilkins, I'm going to appoint James Watts to represent you. He's an attorney here in town. They'll give you his contact information.
When did they stop letting me use my other ear?
Why don't you turn the other way?
Man,
All right, your case has been assigned to Judge Satterfield. She's already set a bond at $4,000.
my bond is $4,000.
That's correct.
Oh, wow.
Your next hearing date is on her felony preliminary hearing control docket on September 15th at 2:30 p.m. and that will be conducted by Zoom. All right, Mr. Deviney, is there anything else we need to do with Mr. Wilkins's case?
No, Your Honor.
Can I get this half? Can I get
All
this?
right, Mr. Wilkins, you are excused.
What is this?
Okay, so I don't really have a whole lot to say about them because they were all so very different. But the first two with Judge Mertz, the first one, she's not following court orders, and it sounds like he wasn't really following the court orders. So, but I think that I think the judge was more angry about him not being able to have any exchange, not just show up to it, but have none of it ever happen. So he didn't get to see his little ones. He hasn't for a while. And then the second one with Judge Mertz, to me, it sounded like the attorney was trying to slip something in there, hoping that nobody was going to read it. And then it would be in a court order, and then they would have to abide by it. That's what I was thinking, but I don't know. You know, I'm always skeptical. And then, let's see, Judge Chisholm. You know, I've rarely seen him. Well, first, the lady didn't explain it very well at all. She couldn't explain what she was doing very well. It took a lot for him to get the information out of her, because she couldn't understand, you know, driver's side of the car, passenger side of the car, front end of the car. You know, there's a difference. So, and then let's see, the last one with Judge Crum. I just threw that in because I had it and it was just kind of silly. So I figured that would be your palate cleanser for the night. So thank you guys for watching, and I'll see you another time.